right, good.
Well, hello, folks. Les Goldstein signing in here, President of Personal Financial Strategies, located in beautiful Park Ridge, Illinois. And we're bringing to you another webinar. And today's webinar is on a very important topic that, unfortunately, the great majority of people don't want to address, right? Estate planning. I'm not quite sure why they don't want to address it. I'm sure Gregory P. Terza, our estate planning attorney, has a position on that. I've got some thoughts too. But bottom line is people don't pay attention to this stuff. And one of the benefits of being a PFS client is we have a wonderful team. I head up the financial planning area. Mr. Terza heads up the estate planning area. Larry Brown heads up the tax planning area. And we work together in an integrated fashion to really be able to help our clients achieve their goals.
Correct.
So the estate plans that you write are good ones. I mean, you wrote mine.
Absolutely.
You wrote my wife's. You've written the estate plans for over 100 clients of ours. And we're delighted with the work and the quality and the level of attention to detail. Your wonderful helper, Amanda. She's great, you know. But let's talk about plans that don't work.
Right.
Can you give us some highlights about, you know, things that you've seen in your, I won't tell people how long you've been doing this, but
That's okay.
26?
Oh, come on, I wish.
No, just in the estate planning area.
I transitioned out of litigation just under 20 years ago.
20 years ago. Okay, so I want to tell you that if you need brain surgery, you're not going to go to your GP, right?
Right.
So if you need quality estate planning, don't go to the guy that, you know, you handled your ticket in court, you know, for speeding, or the closing of your house. And I can tell you that as a fact. Larry Brown, who's our CPA here, is also an attorney. And the minute Greg came and joined us and, you know, offered his services to our clients, Larry was absolutely delighted to never write another living trust again, because it's not what he does.
It wasn't his forte.
Right. So, sir, would you please share with us some of the things that you've seen? And this webinar is designed to provide you with a cautionary tale of it's better to take action and get your stuff handled, right?
Yes.
So, Mr. Terza, please share with us some of the things you've seen over the years.
Yeah, this is about the bad things that can happen in the states that are not properly planned. The official title of it is The 9 Sources of Heartbreak Caused by Defective Estate Plans. When I first transitioned out of the practice from litigation to estate planning, I had a client for whom I had handled a divorce who gave me her paperwork for her estate plan, and I noticed that the mortgage on the home, which she had been awarded in the divorce proceeding, had been paid off, and I asked her how that happened. Well, it turned out that her father was in the nursing home with Alzheimer's, and her attitude was that because he had been more generous with her sister during his lifetime than he had been with her, she simply helped herself to the money and paid off her mortgage. Now, that is not legal. It's certainly a breach of her duty, but it's a cautionary tale in the fact that powers of attorney can be abused if you do not put them in the right hands or have the right checks and balances to make sure these sorts of things don't happen.
Got it.
Now, most of the heartbreaks that happen as a result of poor planning occur after your death. So technically it's not your heartbreak, it is the heartbreak of the family that's torn apart by bad planning. But there are some cases in which it is yours, okay? And in two cases I can point out. One of them has to do with asset protection. If you are in a vulnerable profession, or if you are in a situation where you're afraid of losing your assets if there was a lawsuit, or you own vulnerable property, you own so-called hot assets, like apartment buildings, and you are concerned that a lawsuit could wipe out not only the value of that asset, but also your personal savings, then asset protection can be very important. You may recall the story of Kim Basinger, who got sued for breach of contract many years ago, and she lost her entire $8 million estate. She lost that lawsuit, and she had to file bankruptcy. And so that certainly is a heartbreak that can occur during your life if you feel vulnerable and you do not have a proper asset protection plan. That is not insurance. Insurance is a good first line of defense, but if it's a case such as in Kim Basinger's, where a breach of contract is not covered by insurance, or there's an exclusion, or you get sued for in excess of policy limits, if you want protection, even if they get past the insurance barrier, then there are certain ways of owning your assets that make it very, very difficult for creditors to reach them.
Okay, so problem area number one, and I know I'm off screen camera here, but that's okay. Problem area number one is giving people power of attorney where you shouldn't.
Right.
Right? Either on purpose or they just put by mistake.
Right.
And number two is not having an asset protection plan.
That's right.
Okay, so like maybe if you're a doctor or
A lawyer.
a lawyer, right? Got it. All right, understood.
That's right, that's right. Or if you own certain assets that are capable of producing liability. The biggest single one that most people, that comes up a lot is apartment buildings, because essentially you own something that's worth hundreds of thousands of dollars, and you're turning possession over to it. You don't know what guests they're bringing in or what they're doing in the apartment. You're putting it under essentially their daily control, and that could be liability producing. Crimes can be committed there for which you can be sued. They can have accidents on the property for which you can be sued, and the consequence of the lawsuit could be the exposure of your personal assets beyond the coverage of your insurance.
Got it. Thank you.
Another peril that can occur during your life is if you put assets in joint tenancy with your children as an asset, as an estate planning tool. People often do this because, of course, it's very easy, it's very inexpensive, and upon your death, yes, it will pass to the surviving joint tenants, your children, and there's no probate. The problem is that if their name is on your assets, and one of them goes to divorce, or one of them goes bankrupt, or they have other financial difficulties, then all of a sudden your assets that you expect to live off of during your life are exposed to their financial misfortunes. And I've seen this time and time again, where the parents make this mistake, and then all of a sudden their home, their accounts end up in bankruptcy court or in divorce court, their children's divorce court, because their litigation exposed the assets to being lost.
All right, so Greg, I am always way better at putting numbers on stuff. Maybe it's because of what I do for a living.
Okay.
So let me just understand this. So I've got a $100,000 CD. It's my money.
Right.
And I'm older, okay, than I am. I'm 75, 80 years old, and I put my son on it just because I want to, because maybe he has access to my accounts, he can see what's going on, so he can track things, maybe he can write a check, but I put him on the CD. Okay?
Usually this is done as an estate planning convenience, so that he would get it upon your death.
Okay.
Giving control over it, that's the sort of thing that people sometimes do when they're in declining health and they want somebody to help out with paying the bills.
Right.
But as a general estate planning technique, it's generally done for the purpose of the right of survivorship and avoiding probate.
All right, so I do this with or without some kind of intent, okay?
Right.
Convenience.
Yes.
And now my son gets in a lawsuit.
Yes.
My entire $100,000 CD is at risk, or half of it?
The amount of your CD that is at risk will depend upon the state that you're. Right now, your son's in Florida, right? So,
well, let's say it's in Illinois.
Okay. Well, it will depend, because the point is that if he gets a judgment against him, and if a citation to discover assets is issued, and he has to come into court and answer questions under oath about everything, all of the assets that his name is on, then this CD, that in your example, is going to show up on that list, and the creditor is going to attack it.
Got it.
Now, how successful he can be, whether he can get all of it or half of it, or maybe you can defend and say none of it, because although the money came from you, but nevertheless, I don't think you'd be able to do that, because there would be a gift of at least half of it presumed as a result of the joint tenancy. And then it becomes vulnerable to the claims of his creditors.
So another major mistake is putting my kids on accounts as a convenience matter, or because I'm trying to do some simple estate planning.
Yes, exactly.
Thank you.
Exactly.
That's very large.
Joint tenancy is a very dangerous way to plan. Now, there is another problem that has many facets to it, having to do with beneficiary designations. Beneficiary designations can be very perilous, and in one such case, that was reported in the papers recently. A couple, their name was Friedman, Mr. and Mrs. Friedman. She had a retirement plan at work. And she kept getting these notices in the mail saying that there was no named beneficiary. And they called the office and said, well, if there is no named beneficiary, then it goes to your spouse, which was her husband. Well, then she died, and they went through their records, and it turns out that 27 years ago, before they married, she had named her sister as a contingent beneficiary on her retirement plan. There was a named beneficiary. And as a consequence of this, it was the sister that got the entire retirement plan and not the husband. Beneficiary designations are perilous in many ways, and so you have to regard them with great care. Very few of my clients know who the beneficiary is on their accounts, and these days there are beneficiaries on everything. It used to just be life insurance and retirement plans, but today you can put a beneficiary on an investment account. It's called a TOD, or transfer on death. You can put a beneficiary designation on regular bank accounts, checking accounts, savings accounts. It's called POD, pay on death. You can even put beneficiary designations on vehicles now. In some states, you can have beneficiary designations on deeds to real estate. Not Illinois yet, but if you own out-of-state real estate, there are some states where you can do that. And so it's very, very important to pay close attention to it. Not only what happens upon your death if your primary beneficiary is alive, but what if your primary beneficiary is not alive? A lot of people don't name contingent beneficiaries, or they don't really know who it is or what the terms are. For example, does it go to the kids? And if so, if a child is deceased, does it go to that child's children or to the other children? The beneficiary designation is like a mini estate plan, and it's very dangerous to try to write those yourself. When you're opening an account, your primary attention is on the value of the account, the investment objectives. And that place on the form where you fill in the beneficiary is oftentimes given very little thought. And yet there it lays, year after year, decade after decade. And if it isn't given careful attention, then it can create serious problems upon your death. Now, the consequences of not naming a beneficiary, let's say there wasn't a beneficiary on this plan or on a life insurance policy, well, then you have to turn to the terms of the policy. Sometimes it will say, if there is no named beneficiary, to the spouse, and then to the children. Sometimes it will say, if there is no named beneficiary, then to the estate. And if it's to the estate, guess what that means? It means it goes through probate. And then it will go to whoever the heirs are according to the law of descent and distribution of whatever state that the person died in. And so not naming a beneficiary is very dangerous. If you have a divorce situation and you don't change the beneficiary on your life insurance policies, on your retirement plans, on your annuities, then very likely the ex-spouse will receive the assets. Now, there's a lot of controversy about this. There's a law in Illinois that says if you die and you have a will or a living trust, then the divorced spouse is treated as having predeceased you. However, there's no similar law for life insurance policies and retirement plans. And then some people say, well, but in the divorce judgment, there's always a clause, a standard clause that says each party waives any interest they have in the assets of the other. But that's a very dangerous thing to rely on. Some cases have gone one way and other cases have gone the other. And so when a divorce happens, it's very, very important to revisit all of those beneficiary designations and to make sure they get changed to what you want and not rely on what the law says about it, because the law could end up giving it to the ex-spouse. Lastly, with regards to second marriages, there's a big surprise with regards to company-sponsored retirement plans. When you're in a second marriage, it's not unusual to want to name your children from a previous marriage on the 401k or the 403b plan. But if you're married and you die with a 401k or 403b plan, guess who gets that plan? The surviving spouse. This is by law. By federal law, these company-sponsored plans have to go to the surviving spouse, even though you named as your children as beneficiary. And so, unless there's a spousal waiver, then it will go to the surviving spouse. The divorce judgment, waivers in a divorce judgment do not constitute a waiver. Waivers in prenuptial agreements do not constitute a
All right,
waiver.
so what does that mean? Okay, because now you're speaking, some legalese here, and I want to make it very clear. So I have a 401k plan at work.
Yeah,
I have my wife on as primary beneficiary. Okay?
that's no problem because
Okay.
that's what the law says you're
All
supposed to
right.
do,
Now I have my kids as contingent.
right?
Okay.
But if you changed it to your kids.
And I get divorced. Okay, I get divorced. I no longer want that person, my ex-spouse, to be my beneficiary.
Right,
And I want my kids to be beneficiaries. Okay? Maybe I don't do anything to the plan. I just leave it alone. The 401k, I make no changes. Do my kids automatically step up as primary, at least on the 401k plan documents?
no.
No.
No, your
Okay.
ex-wife will get it. Now,
No, all right, but now, all right, I remarry,
right,
okay, and I die.
right.
Who gets the 401k plan? My ex-wife, my current wife, or my kids?
That's a good question. It is your current wife that would get it, not
Got
your
it.
children.
Got it.
Okay, which is probably not your intention if your thought was that upon divorce that your first wife was out and that your children stepped up, as you
Got
say,
it.
into primary position.
Got
But even if, let's say you remarried and you paid attention to that beneficiary designation.
Yes.
And you say, I want to fill out a new one now because I
Okay.
want to name my kids as beneficiary.
And I name them as
And you
primary.
name them as beneficiary and you sign it and you submit it and they accept the beneficiary designation and
Okay.
you die, they still write the check to your new wife.
Got it.
Not to your children.
So that may not be something I'm against, and I might be okay with that outcome, but I should at least know that that's the outcome if I don't pay attention.
Yes.
Got it.
Yes, absolutely.
Got it. So disinheriting children from retirement plan accounts is a very significant, let's call it estate plan heartache.
Yes.
Got it.
Absolutely.
Okay. Thank you.
There is also a way that typical plans that often disinherit grandchildren. And here's how that happens. If a client comes to me with a typical plan that says all of my assets to be divided equally among my children per stirpes, which basically means that if a child dies, then that child's share goes to that child's children, that is to say your grandchildren. And I say to them, why did you include your in-laws in your estate plan at the expense of your grandchildren? And they say, well, my in-laws aren't mentioned there. My in-laws are not beneficiaries. And I say, well, but let's think about this for a minute. Your children are not going to predecease you. Remember the provision says if a child predeceases me, then it goes to the grandchildren. But that's not going to happen. Your children are going to survive you and then someday die with that inherited wealth. And having survived you and having received an outright distribution, and the child dies with a will saying everything to my spouse, then it goes to the in-law and not to the grandchildren. And so proper estate planning can allow you to choose not only your primary beneficiary, but where you want it to go when that primary beneficiary dies, which is almost always the grandchildren. So if you want to preserve your grandchildren's inheritance, and you do not want to see them disinherited in favor of the in-laws, then proper estate planning is required.
Well, thank you.
Okay. Now, children can also be inadvertently disinherited by remarriage. This is the most common way that children are inadvertently disinherited. We already spoke of 401k plans that automatically go to the surviving spouse in the absence of a waiver. But there's also something called a spousal right to renounce and take a statutory share. If you die with a will that leaves everything to your children, and your spouse, your surviving spouse, new spouse, comes along and says, I'm entitled to 1/3 of that. And she can go to court and claim 1/3 of the estate in spite of your instructions. Now in Illinois, we happen to be singularly fortunate in this regard because we are one of only a couple of states that says that the surviving spouse cannot renounce against a living trust.
Now, what does that mean?
So if you do a living trust, then the surviving spouse cannot renounce it and take a statutory share. That is to say, if you name your children as beneficiary of a living trust, then your children will receive it. There is no spousal right to renounce. Okay?
Thank you.
So in second marriage estate planning, you're essentially planning for three families. You're planning for each other. You want to secure each other's financial future. And then there's the husband's children from a previous marriage and the wife's children from a previous marriage. And so it's very, very important to, in the counseling process, to address all of these concerns and make sure that if you are the first to die, then upon the second death, your children will not be left out. All of the assets will not simply go to the survivor's children, that they'll be divided between the survivor's children and the children of the first to die. Now, there's another big problem when it comes to the loss of your assets to your children's creditors. Let's say that you die and you leave your children an outright distribution, and there are some recent cases in Illinois where this happened. And the children are in financial trouble. There's a lot of people in financial trouble these days, underwater mortgages, lots of bankruptcies out there. If this happens and your children receive an inheritance, then that inheritance can be lost to that bankruptcy. If the child files for a divorce, then those assets can be lost in a divorce proceeding. If the child is sued for something, the child can lose those assets in a lawsuit. And so if you simply leave an outright distribution instead of putting a protective wrapper around those assets called a trust or a spendthrift trust, then your assets that you worked and saved throughout your entire life essentially are vulnerable to your children's lawsuits, creditors, bankruptcies, divorces. Now, the last point I want to make is this. And I call this, how to guarantee there's going to be a fight over your estate when you die, okay? And the way to guarantee it is this. It's not a literal guarantee, but this is how a lot of estate litigation happens. You make a change in your estate plan late in life in failing health. And the change is a significant change from the previous scheme, dispositive scheme you've had for years and years. And the change is in favor of a caretaker child. If you do that, and I'm not saying it's the wrong thing to do. I had a client recently who made such a change. He had an equal division between the two daughters for years and years and years and years. And within weeks of his death, he said he wanted one child to get 75% and the other one 25%. And I told him of the problems and the possibility for litigation, and I got his permission to speak to both daughters about it, and the daughter whose share was being reduced said that she doesn't like it, but she understands it, and he's mentally competent, so he's able to make that decision. And so I got I made sure that he was mentally competent to make the decision, and we went ahead and did it. And there was no post-mortem litigation. But if it's not done carefully like this, then the fact is that the child who's disinherited or the child whose share is reduced is bound to file a lawsuit claiming tortious interference with inheritance, that the child who was the caretaker spouse somehow unduly influenced dad into making this change, and they can wind up in court for years, and a lot of the money that is left can end up being spent on attorneys and in courts in litigation. And so if you make any changes in your estate plan late in life, and if it's a substantial change, then it's very important to do it in a way that dots your I's and crosses your T's so that there is no potential for estate litigation when you're gone. Okay, those are the 9 items that I wanted to share with you today with regards to how estate plans can end up in litigation and end up with the heartbreak of either yours if the problem occurs during life, like in joint tenancy or in asset protection situations, or for your heirs.
Wonderful.
Okay.
I want to thank you for sharing this information with us, Greg. And I know there's no simple solutions in life in most cases, but the type of planning that you do for clients in general is not will-based.
No.
It's different.
Correct.
And so for these 9 heartbreaks, is there one basic solution?
The centerpiece, you might say, of a plan, the foundation upon which anything more involved is written,
Okay.
is the revocable, a properly drawn revocable living trust.
Okay.
Not a throwaway trust, not a revocable living trust that is called a bare bones trust that just leaves outright distributions to the kids. But a properly funded, that is say the assets, after it's created, the assets are actually transferred into the trust, and if it has the proper terms in there for spouse and children, then that is a good foundation. Now, if you move on to things like asset protection,
Yes.
those involve the creation of other entities. Or
Tax planning.
tax planning, you might want a trust having to do with your IRAs, which is good for deferral of income taxes for your children and protection of your assets. If you have a life insurance policy, you want to have that excluded from estate taxes, both Illinois and federal estate taxes, then there's
Okay.
a certain trust for that. But all of these things will work off of the foundation of the revocable living trust.
Got it, thank you. Now, in class, because many of you know us because of our retirement planning classes at the local colleges, Greg comes in and teaches one of the sessions on estate planning, and you always share an example on the board that opens up people's eyes and they go, what? So I'm wondering, let's share that briefly here.
Oh, sure.
Because I think this is a wonderful way, let me adjust the camera, this is a wonderful way for people to see how things can go wrong. And while we certainly would rather talk about how things can go right, let's share here how things sometimes don't.
This
Now, let's
illustration,
see if we can see this. Well, let's do the best that we can. Let's put the numbers up there, and we'll work with it. Okay.
okay, I have the number $1,500,000 written there.
Okay.
And this is a second marriage illustration, a remarriage illustration. And the scenario is that a brother and a sister, or two brothers or whatever, the two children are told by the attorney at the reading of the will that that dad died with the will. He had an estate of $1.5 million, and they are the sole beneficiaries under the will. And so they say, that's wonderful, that's $750,000 each. And the lawyer says, well, not exactly, because after your mother died, your father remarried. And under Illinois law, if you die with a will, then the new spouse can claim what is known as a statutory share. She can renounce the will and claim a statutory share. And that statutory share is 1/3. And so that, in this case, would be $500,000 out of the $1.5 million. And the children say to themselves, well, we don't like it, but if that's the way it is, $500,000 each is still, a pretty nice inheritance. And the lawyer says, well, not exactly, because your father died with this 401k plan of $600,000. And the kids say, well, so what? I know very well that we were the beneficiaries on that. And the lawyer says, yes, you are the named beneficiaries, and you're the sole beneficiaries under the will. But under federal law, the plan administrator is required to give the money to the surviving spouse. This rule, by the way, does not apply to IRAs. It only applies to company-sponsored plans. And so, as a result of that, there's $900,000 left over. But is there really $900,000 left over? Not really, or not exactly, as we say, because this is the amount that the surviving spouse has a right to renounce against, only the probate estate. And so now, $1.5 million becomes $600,000 because we have to take the right to renounce out of this. Except not exactly, because the home he put in joint tenancy with his new spouse. He wanted her to have the home, which is reasonable, that's $300,000. And the kids say, but the will left everything to us. And the lawyer explains that you cannot bequeath joint tenancy property. Joint tenancy property passes automatically by right of survivorship. And so now we're down to $600,000, against which the surviving spouse has a right to renounce and claim $200,000, and now the two children are splitting only $400,000 or $200,000 each. Now this is clearly not the way Dad wanted it, okay? Dad named the children as sole beneficiary under the will. Dad named the children as sole beneficiary under the 401k plan. The only thing he really wanted his new wife to have is the home. And this is not unusual because oftentimes in second marriages, both sides have inherited wealth from their first spouse, or they got wealth out of the divorce from their first spouse, and so they come into the marriage with independent wealth, and each one of them just wants to take care of their own children from a previous marriage. But as you can see, his overall intention here was completely frustrated.
Wow.
To the heartache of his children.
Let's summarize this, because this is so incredibly painful, and this strikes me as something that can happen a lot.
Yes.
So the man had $1.5 million, including a $600,000 401k and a $300,000 house.
Right.
He wanted his kids to get everything except the house.
Right.
So the kids should have gotten, in the planning of the dad, $1.5 million minus $300,000,
$1,200,000 or
$1.2 million.
$600,000 each. Yes.
and instead they ended up with how much each?
$200 each.
Wow.
Yeah.
Folks,
Big difference.
pay attention to this webinar. Go to Gregory P. Terz's website, which is what, legacylaw.com?
Legacy Laws.
Laws with an S on the bottom, legacylaws.com, and share this information with your friends and your family and your loved ones. Get your financial house in order, and that includes having an intelligent estate plan. I want to thank you, Mr. Terza, because my goodness, this is stuff people need to know.
Thank you very much.
Pleasure. Thank you.
Thank you very much for listening.